Good evening. I'm John Miko, the president of Founding Forward, and on behalf of the entire staff and board and leadership of Founding Forward, it's my pleasure to welcome you to tonight's Liberty Series. A few housekeeping items before we begin. First of all, if you would take a moment and please silence, or better yet, turn off your cell phone. We would certainly appreciate that. Tonight's program will be a moderated discussion. We will have questions, and we'll get to as many as we can. You should have note cards there. Please feel free to write your questions. We will have our staff come through towards the end of the discussion to pick them up. And I normally say, please, no more than 2 or 3 sentences, et cetera, as you all know. But I really don't need to say that because we'll have total control over those questions because we're so write neatly and be succinct. That's my advice to you to get your question asked. Founding Forward, as you know, is the nonprofit charity that's affiliated with the Union League of Philadelphia. We are the result of this merger with Freedom's Foundation and the Legacy Foundation of the Union League. We are focusing, of course, on civics education. That is our focus on our beautiful campus at Valley Forge, but also here in Philadelphia and in Lafayette Hill. I invite you to visit us. We have scheduled visits for anyone who wants to come, tour the campus, the beautiful Medal of Honor Grove, learn more about what we do and how you can help us do it. So you can go online either to the Founding Forward site or the Union League site and get that information. And of course, how you can help us right now is you can make a gift. We need your support to do the work that we need to do, and our work is big because we need more and more good and educated citizens. So I thank you if you've made a gift already, and if you haven't, please make a gift to Founding Forward. We will spend and use your money wisely to educate the next generation of citizen leaders. A few other housekeeping items for our attorneys who are interested in some CLE credit. We have forms over here. You can come up afterwards. If you are looking for more than one state or the District of Columbia, fill out more than one form. It can be the same form. Any other questions we can answer up here for our attorneys. And at the end, we will have a survey or QR code that you can just get with your phone and fill that out. We really would appreciate your insight and thoughts on tonight's program as well as ideas on other ones. Speaking of other ones, we have a program next Thursday, 2 days after the election, and it's on 2024 election, outcomes and analysis. I am certain we will have much to talk about. That program is at Liberty Hill, and then we have 2 others coming up. One is on November 19th, a public affairs program on artificial intelligence. We have some leading industry people coming to talk about AI. And another Liberty series on November 20th, which is the 150th birthday of Winston Churchill. So we have a program on Winston Churchill. And finally, December 14th, everyone here is invited to a great program on the Valley Forge campus in the Medal of Honor Grove, where we're going to place wreaths across the Medal of Honor Grove in honor of all those who received the Medal of Honor. So please look for information on that December 14th. And now, without further ado, it's my pleasure to introduce the man who will introduce our program, a member of our speaker committee, Mr. Adam Scaramello. Adam.
Good evening, ladies and gentlemen. We're in for a real treat this evening. Given the number of cases that have come down that are of remarkable import, given the esteemed members of our panel, we're in for a memorable evening. I'd like to introduce Michael Moreland. He's from Villanova University, University Professor of Law and Religion, and Director of the Eleanor H. McCullen Center for Law, Religion, and Public Policy. He's clerk for the Honorable Paul J. Kelly Jr., United States Appellate Court of the 10th Circuit, and has served as Associate Director for Domestic Policy at the White House before or under President George W. Bush. Next, we have Will Creeley. He is the Legal Director for FIRE, Foundation for Individual Rights and Freedoms, FIRE is an organization that many of us knew well here at the League, where he coordinates legal advocacy and oversees FIRE's litigation, legislative policy, policy reform, and targeted advocacy departments. He has authored amicus briefs submitted to courts nationwide, including the United States Supreme Court and several courts of appeal for the United States Circuit. Robert Corn-Revere has served as FIRE Chief Counsel since 2023, and before, he acted as outside counsel for FIRE's Stand Up for Speech litigation project, successfully litigating on behalf of college students and faculty whose First Amendment rights were violated. Best Lawyers in America have named him Washington, D.C.'s Lawyer of the Year in areas of First Amendment law and litigation. In 2017, 2019, and 2021. Founding Forward is proud to introduce Michael Moreland, Will Creeley, and Robert Corn-Revere. Thank you, gentlemen.
Well, thank you very much for that introduction, and thanks as always to Founding Forward and the Union League for putting on such tremendous programs. So you guys are First Amendment lawyers. I teach First Amendment, but we're going to start with something other than the First Amendment, and that is the case that I think garnered a fair amount of attention when the court decided its last few cases last summer from the 2023-24 term. And that was the Loper-Bright case involving Chevron deference, which sounds boring and technical, but it did get a lot of attention. And so I'm wondering if one of you want to weigh in on what that case was about and why it is potentially significant.
Sure, we're going right into the deep end, right off the bat. If you had Chevron deference on your bingo card tonight, folks, you're in luck. Yeah, Professor Moreland, that is a big case. It may be in some ways perhaps the most consequential of all the cases the court has decided recently. Chevron deference is a judicial doctrine by which courts have deferred to agency interpretations of congressional statutes. Under the Administrative Procedure Act, they say if there's a delegation of power to the agency's interpretation of that delegation and that statutory authority has to be reasonable. In other words, agencies have a lot of power, and Chevron deference was a judicial doctrine saying that's okay, let them exercise that power. As long as it's not unreasonable, let them cook. And Loper-Bright changes that math, and the court said that this delegation had no support in the statutory text, and we're going to change things. So it's a real shift in the balance of power between the administrative state and Congress.
Yeah, I think it's important that we do the administrative law case first before people start getting drowsy.
Yeah, right.
And I have a somewhat different take on Loper-Bright because I've never been a big fan of the Chevron doctrine, and part of that comes from the fact that for 4 years earlier in my career, I worked at the Federal Communications Commission. That was the previous time I've been chief counsel. Right. And the FCC is an agency with a lot of power, and there it is at the intersection of the First Amendment and administrative law because it regulates broadcasting, cable, and communications media. And so if you're giving a federal agency a lot of deference, as the Chevron doctrine did, then you're also giving that agency a lot of control over speech, which is what makes that kind of delegation of congressional power dangerous if you care about the exercise of First Amendment rights. Now, when I worked at the FCC, we had a saying, and that is, it's a good thing we're not the Consumer Product Safety Commission, or someone could get hurt. And it was, having lived through that experience, is part of what made me even more interested in being a First Amendment advocate, so that in my post-FCC career, I prefer to think of that agency as the defendant.
Right.
And of course, if, as mentioned, we welcome questions from the audience. If there are further questions about the administrative state and the Supreme Court's decisions in that area, we welcome them, and we can try our best to weigh in on them.
One more point on Loper-Bright. I'd be curious for what you both think. One of the things that folks have argued about Chevron deference is that it's made Congress lazy. right? You can kind of give the agencies a big idea, and they'll fill in the blanks for you. And that means you've got a lot of unelected bureaucrats who are tasked, as Bob notes, with deciding what a gigantic federal agency does all day. And maybe post-Loper-Bright, Congress, and we can dream, right? It's a couple days before the election, let's be optimistic. Congress can do some work and write legislation with more specificity to guide those agencies now that they don't have the blank check that perhaps they did under Chevron.
I think that's absolutely true. I think Congress has gotten extremely lazy because the agencies are there. They're more than happy to fill in the gaps if legislation is imprecise or if it leaves an expansive grant of power. And so, you know, the attitude grows up in these agencies, or at least the one I'm most familiar with. Basically, we get to do this until a court tells us to stop.
Right.
And with a doctrine like the Chevron doctrine on the books, courts are less likely to say stop when you have this unreviewed exercise of administrative power.
Right, and in that sense of a piece with, again, some may have heard of it, but, and certainly some of these cases, but involving the so-called major questions doctrine, where Biden student loan forgiveness, the OSHA vaccine mandate, some EPA regulations, that these kind of broad statutes where Congress kind of throws it up to the agency, but the court saying that Congress, if you haven't directed the agency, if you haven't given them this authority, we're not going to just assume that they can go ahead and exercise it.
Well, and there's another dynamic that happens too, and that is you will have agencies that have supervisory power over agencies through their budget and so on. And you will see Congress as a body being imprecise with the legislation, but then you will have committee staff and others leaning on the agency to essentially adopt the law they couldn't get through Congress.
Right.
And so you have this sort of shadow body of, it isn't really legislation, it's administrative law, but with a doctrine like Chevron, it becomes almost unreviewable.
Last thing, thinking of founding forward and the work of raising another generation of civic leaders, I've been a proud participant in Good Citizen Day here, and I think about it in these terms. I've got a 10-year-old son and a 7-year-old daughter. My 10-year-old son is just getting the basics of our of our country, and he's getting the beginning stage of civic education. Says, all right, judicial, executive, legislative. He's not learning about administrative, right? So we'll see what happens next.
Well, now let's turn a little bit to the First Amendment, which is your areas of expertise. So a lot of these cases folks may have heard about, but some were probably less report on. So there were a pair of cases, both brought by a trade association called Net Choice. This involved statutes in Texas and Florida involving the regulation of social media companies and their control of their content. Like, can they deplatform people? Can they curate the news feeds in certain ways? Can they emphasize certain themes and not certain themes? And so this was a challenge brought by the Trade Association of Social Media Companies against the statutes in Texas and Florida that tried to do this. And the disposition of the court was a little, well, let's let things cook a little longer. You were saying earlier, Will, but what do you want to start talking about Net Choice, and we can see where the conversation goes?
Yeah, I'm happy to, again, take a kind of first cut here, but Bob, jump in if you'd like. The question here is whether states have power over private social media companies and can kind of dictate to those social media companies, once they attain a certain size, who they allow on their platform and who can say what. Have they got so big, in other words, that now there's a role for government to make sure that certain voices, in Texas and Florida's cases, they were concerned about conservative political voices, are being silenced? Can you kick off, say, former President Trump off your platform? Or at some point, have you become so big that you are, as the court said in a case called Packingham, the new digital town square? In other words, are you such a big place? Is the conversation happening on Twitter or X to such an extent that there's a role for the government and you should have some kind of recourse if you're silenced? Now, Bob and I both work for FIRE, and so we agree here. But I'm promising you to give you both sides of the issue. The argument raised by Florida and Texas and argued in the court and agreed to by some of the court members is that at some point, you're more like a telephone company, right? Ma Bell or AT&T or Verizon, they don't get to say, well, listen, we don't like your politics. We're shutting you down. You can't call your friend to talk about how you're voting for the GOP or whatever, or call the Anthony Fauci a liar or whatever you might be saying on the phone. At some point, you are now essentially a common carrier, and as such, you can't discriminate on the basis of viewpoint. You've lost some of the ability to regulate a speech on your platform. The other argument, and here I'll kick it over to you, Bob. Let's see. The other argument is that, no, actually, private companies are private companies. They don't become wards of the state by virtue of their success. And really, the state has no business telling a private company what speech it can or can't allow.
Yeah. Well, let me back up
Please.
just a little bit to set the stage, because this is part of a trend in Supreme Court litigation that's been going on since 1997. Ever since the internet became a thing, and the first thing Congress did was decide we ought to regulate that. And so it went to the Supreme Court. You had Reno versus ACLU, which basically held that the internet was protected with full First Amendment protection. And that's been the law since 1997. We're now seeing a new sort of series, various permutations of online regulation. And a lot of those were coming to the Supreme Court as a group this term. The net choice cases were just among them. There were 8 different First Amendment cases before the Supreme Court this term. Made me believe that this was going to be the most consequential term in First Amendment law since I've been practicing law. So I've been practicing for over 40 years. And so it promised to be a huge term to basically flesh out what the First Amendment protections were going to be for the internet. In the net choice cases, as Will mentioned, the states had decided in response to deplatforming politicians who had violated their policies that the states needed to regulate this, and it was going to prevent, quote, censorship by private speakers. You had other cases involving whether or not social media companies were public officials when using their private social media accounts. If they conducted public business, were they going to be treated like a public forum? And then you had the informal regulation cases, whether or not you had the Biden administration whispering in the background to social media companies, whether or not they were going to be, whether or not that was a First Amendment violation. The weird thing is that you had a political valence that went in opposite directions in these cases. And the difficulty is in the net choice cases is you have the states stepping in the name of free speech to impose state regulation. What could possibly go wrong? You're going to have state governments motivated by their own political pressures to decide they were going to be deciding whether or not social media companies were making the right editorial choices. And that's what distinguishes it from phone companies. You don't have phone companies that throughout their history have made these kinds of moderation decisions. And the internet would essentially be unusable if you didn't have this kind of private moderation. And the question was going to be whether or not you leave it in private hands, as imperfect as that is, or allow someone to exert political control. And as you say, I mean, the Supreme Court in a way ducked the question, but in a way didn't. You had 2 states, Florida and Texas, that had both adopted very similar laws, go to the Supreme Court, and the Supreme Court doesn't decide the case. They decide instead, we need to know more. But the 2 appellate courts had gone in opposite directions. The 11th Circuit, in evaluating the Florida law, held that it probably violated the First Amendment. The 5th Circuit, in reviewing the Texas law, held that this is just censorship, and we need the government to stop this censorship, totally inverting the normal way you analyze First Amendment questions. The First Amendment is a protection against state action, not against private action. And so you have these 2 cases, opposite conclusions going up, and the Supreme Court says, we need to know more about how these laws operate before we decide it. But the court also said, by the way, we think the 5th Circuit is completely wrong, and the First Amendment does apply in these cases. What's even more interesting is sort of a background part of it is that this is an opinion that originally had been assigned to Justice Alito. Once he wrote the opinion, the majority evaporated, and he ended up writing a concurring opinion. And the majority opinion, written by Justice Kagan, basically affirmed these basic First Amendment principles that go back to Reno versus ACLU.
It did strike me, I mean, one of the interesting areas here was how the precedents with regard to editorial control. So there's a case from 50 years ago, Miami Herald, involving interestingly, a Florida statute that required that when a candidate was attacked, the candidate had a right of response on the editorial page of a newspaper. For those of a certain age, there used to be these things in hard copy called newspapers, and you have it delivered to your home, and you would open it up and read it. And so in that world, the Supreme Court said, no, the state can't require that because the editorial control over the newspaper that the Miami Herald has gives them a First Amendment right to control their editorial content. So the interesting question in Net Choice was, does that same rationale apply in the digital era with regard to Twitter and other users? And then the interesting issue that came up, as you guys know, at oral argument was, well, how broadly does this sweep? It's one thing you say, well, X or Twitter can curate their feed and privilege certain content. What about Uber? What about Gmail? If it applies to them, then it starts to look more problematic if all of a sudden we say, well, Uber or Gmail can start engaging in kicking people off their platform. So I don't know if you have any thoughts about that.
Yeah, I do think that the court, and I'm glad, I was just about to get to the precedent, so I'm glad you got there. I do think the court ended up, this is me speaking both personally and in my capacity as legal director of FIRE, I do think the court got it right. I don't like, as Bob says, when the state says that a private company's decisions are censorship such that the First Amendment no longer applies. That, in fact, the private company's First Amendment right to run itself as it sees fit without the hands of government over it takes a back seat. The other analogy here is to the Hurley case, where you've got a parade, St. Patrick's Day parade in Boston, and whether or not the parade organizers could be forced, this is an anti-discrimination clause, but could be forced to include LGBT marchers in their parade when they didn't want to. They said, our parade has a certain message. If we have to be forced by statute to include other marchers, then our parade is no longer our parade. So too here. If I have a private company and I'm committed to certain types of values, or I want a certain kind of speech on my social media platform. Let's say I start a platform, this is the No Nazis platform, right? Great, come on over. You're not a fan of Nazis, you're gonna have a good time on my social media platform. And all of a sudden the government says, well, now you're 50 million users. Guess what? You no longer get to control who comes in and who can use your service. In fact, we're gonna tell you that you can't ban political speech. Wait a second. Now, the fun of the oral argument was hearing the government for the state of Texas say that was censorship. And the justice is saying, no, censorship, and this is Justice Kavanaugh, I think, I don't want to butcher his line, but the justice says, the First Amendment applies to who? Yeah. The government. The First Amendment doesn't apply to private actors making private decisions like the newspapers in Tornillo about what content they run. So once we've got that basic rule reestablished, now we go back down to the appellate courts and we'll see what happens next.
That's right. And the weird thing about these two state laws, both in Texas and in Florida, is that it's rare to see a government rewarded for writing a very broad, expansive statute that regulates speech. But what happened in these cases is the laws were adopted in response to a particular thing, and that is politicians being deplatformed because of their violating the rules, the terms of service of these various platforms, particularly after the January 6th assault on the Capitol. And so that happened, and then the legislatures responded by saying, we're going to go after those woke social media companies. We're going to pass these rules that don't let them make those kinds of editorial decisions with their terms of service. But they were very sloppy in their drafting. It could apply to any kind of online service. And so when it got to the court during the oral argument, as you pointed out, you have all these questions. Well, this law is written so broadly, it could apply to Uber. Are you going to let them deny rides to people of the wrong political party? It could apply to Venmo, which is a payment service. It could apply to anything. And as I say, it's really rare that you'll have courts rewarding states, or the federal government for that matter, for writing laws in such a broad, expansive way that they cover everything. But essentially, that's what happened here. The court sent it back to both courts, vacated both lower court decisions, and said, we want you to more carefully define what it is you're challenging, what services have editorial functions, and then we'll take a look at it. But here are the rules, and it laid out the First Amendment rules that would apply.
Well, one more point here. As a civil libertarian, I'm always nervous about the government coming in and telling people what they can and can't say and do. Private companies, individual speakers, same deal. One thing I think is interesting about the political response that got these laws passed in response to deplatforming conservative speakers, there's always the marketplace, right? In the United States, you build a better mousetrap. You don't like what Twitter's doing, you go and found your own social media site here, Truth Social, right?
Or go by Twitter.
Or go by Twitter, right? The market will work. And that's, I think, vastly preferable. If you don't like what the newspaper's publishing, you think that, you have a right to respond, start your own newspaper. It's the same thing I tell my kids, again, my 10-year-old and my 7-year-old. You don't like what he's doing, go do your own thing, right? Same deal here. And to that extent, I think this is kind of a success story. Now you've got different places where folks can speak their minds, and that works, right?
We'll come back to some First Amendment cases if we have time, but I thought we would maybe zoom out a little bit, talk about the Supreme Court in general. Lead editorial in the Wall Street Journal today talking about worries about court packing, ethics requirements, term limits, other kinds of efforts to go after the Supreme Court. In some ways, maybe nothing new. He attacked the Supreme Court too in his time, and so maybe it's nothing new about politicians running for president or presidents going after the Supreme Court for what they perceive to be its mistakes. But maybe just in general, kind of your sense about this moment and people attacking the court's legitimacy, certain decisions, of course, I guess primarily Dobbs, but others that have been a focus of a lot of anger, and how you think we should think about those questions.
Well, this is pure punditry on my part, right? So this is me speaking personally and not as legal director for FIRE. But one speech, one great American document that we talk about all the time at work is Judge Learned Hand's Spirit of Liberty speech. And I regret to say I don't have it committed to memory, although catch me next year, I might by then. But the gist of it is that the Constitution is great. The First Amendment is great. But they're just words. If the law and our faith in it dies in the population, in the citizenry, then it's
law, no constitution.
then it's
can
just
save it.
right. Then it's just words on a piece of paper. And this is again. I'll be sorry to reference my kids for a third time. They're on my mind. But they tell me, well, what happens if you lose a case, right? We say, I didn't convince somebody. We have to all be convinced that the court's pronouncements have legitimacy. And I think Chief Justice Roberts, to his credit, has done a lot to try and preserve that kind of institutional comedy and institutional respect. We were talking before this panel that I think the average American would be very surprised to know that the court is not always breaking 6-3 conservative liberal. In fact, there's a great deal of interesting ideological interplay between the justices. Think about Justice Alito in the net choice cases writing the opinion. Turns out he didn't have support for it. There are more variations and more alliances, more unlikely bedfellows on the court in the court's opinions than one might expect. And I think that having that kind of recognition beyond just nerdy attorneys like me would be a good thing. I think if folks understood the justices not as political actors, but as people who take seriously their role in interpreting the law and trying to arrive at fair and reasoned decisions, we'd all be better off as a country. So anything that increases the politicization, thinking about the Wall Street Journal's editorial today about the Supreme Court and packing it, anything that increases the political stakes of the court, whether that's denying a sitting president the right to name a justice or rearranging the composition of the court or the amount of members of the court, I'm very wary of. I think we need more stability, not less right now. That would be my take.
Yeah, I couldn't agree more. And even though we're not expressing FIRE positions per se, we're just being pundits on this. I see the Supreme Court as sort of like a national Rorschach test.
Right.
People respond to it based largely on their own view of the issues that come in front of the court. And Will's absolutely right that you don't have this sort of 6-3 divide, particularly when you're talking about First Amendment cases. Of the 8 cases that were decided by the court this past term, 6 of them were unanimous. One was 8-1, the other one was 6-3. Now, that seeming level of unanimity betrays other divisions on the court, and I alluded to that earlier with Justice Alito. But it is a lot more complicated, and it isn't as political. And I also agree with Will that anything that would increase the politics surrounding the court would make it worse, not better. My own personal view, again, not a fire view, is that anything that politics touches, it diminishes or destroys. And the worst thing about the Supreme Court is the confirmation process, which has become a circus. And the ritual that they put nominees through has only increased the political stakes for the court. And it's been that way since the 1990s. It really picked up at that point, and has continued. And that has done nothing but increase the polarization that people perceive about the court. In its operation, I think it does its best to try and stay above the fray. You can take issue with one justice or another, but I think as an institution, it is probably of the three branches, the one functioning the best.
Maybe talk about another speech case from last term, and this was a case involving the National Rifle Association, but not a Second Amendment case. It was a First Amendment speech case. So we talk a little bit about NRA versus Vullo.
Sure.
Yeah, this is a good one. I'll lay out the facts briefly. Maria Vullo was the, what was her exact title? Superintendent.
Director of Financial Services.
Financial Services for the state of New York. And the National Rifle Association was engaged in certain insurance programs with private insurance brokers like Lloyd's of London. And Vullo did not like the way that these programs were operating, and just so happened to be working with the governor who had announced that the NRA and its advocacy were persona non grata in the state of New York, and had big political pushback post, I want to say, with its Sandy Hook, I can't remember which of
the Marjorie Stone Douglas.
Marjorie Stone Douglas, that's right. And so there's a push to get the NRA out of New York, and a lot of political energy against the NRA in the state of New York. So Maria Vullo goes to the insurance companies that the NRA is contracted with to offer certain insurance programs to its customers, and essentially says, nice little insurance company you got there, would be a shame if anything were to happen to it. And I mean, it's only, you know, only a little bit of a joke. I mean, she sent out press releases warning insurance companies to think about their reputation with who they do business with, and to say that she would use the full power of her office to come down on insurance companies that didn't cut ties with the NRA. And in fact, I think, as I recall, Bob, she even went so far as to cut deals with insurance agencies.
Yep.
If they ditched their relationship with the NRA, she would not enforce certain violations that her office had found. So really classic quid pro quo. The technical legal term for this is jawboning, right? Where she was bullying and coercing the insurance companies to toe a particular party line and to cut ties with disfavored political actors. So the NRA brings a First Amendment suit saying, in other words, you can't do this. When the government or a government official leans on a private company in this way, they violate the First Amendment. And interestingly enough, at the Supreme Court level, once the court granted cert, the ACLU, our friends at the ACLU represented the NRA. And again, I think what is, you know, I want to highlight as many of those cross-ideological alliances as possible, because it's in service of a broader principle. Because while this case involves a New York State official going after the NRA, in Fire's brief that we filed with the court, we had plenty of examples of folks in red states going after quote-unquote blue companies, right? There's politicians, to Bob's point about politics diminishing and destroying things, politicians love going after people they don't agree with, and private businesses too. So this one goes up to the court, and I'll hand it over to you, Bob, at this point.
Okay. Well, this is one of those paired cases, because this was paired with a social media case, the one involving the allegations that the Biden administration had been leaning on social media companies to change their moderation policies. They were argued together, and both of them involving this principle called jawboning and the exertion of informal pressure. The NRA case, as Will pointed out, was argued by David Cole of the ACLU, who's just recently finished his term as legal director of the ACLU. He did a brilliant job in the Supreme Court in a unanimous decision written by Justice Sotomayor, held that that was indeed a violation of the First Amendment. Really a no-brainer when you think about it, because the basic precedent covering this was decided in 1963 by the court in a case called Bantam Books versus Sullivan. That involved a Rhode Island law where the state had adopted something called the Rhode Island Commission for the Morality of Youth that would publish its list of dirty books that it didn't think booksellers should have. Now, it didn't have any authority to go after the bookstores, but once it issued its list, about once a week, a cop would come by the bookstores and say, "So you still selling those books?" And miraculously, they weren't anymore. And so that the principle was established in 1963, that you couldn't use this kind of informal pressure to get people, to silence people, and you couldn't impose that pressure on intermediaries. And that is precisely what we had with the Director of Financial Services leaning on insurance companies because it wanted to starve out the NRA because it didn't like its political message. And you get this unanimous decision. At the same time, you have this Murphy versus Missouri, and as Will was pointing out, you have this phenomenon from both sides of the political spectrum. The plaintiffs in the Murphy case there were 5 individuals, but there were 2 attorneys general from red states, Louisiana and Missouri, that were arguing that this was a huge First Amendment infraction because you had this private pressure, this behind-the-scenes pressure on social media companies. Now, mind you, these are the same attorneys general who are supporting direct regulation of social media companies, no matter what's a little bit of inconsistency among friends. And so in that case, however, fortunately, the court affirmed the basic principle from Bantam Books and extended that through Volo. But in the Murphy case, the court, as it did in the net choice cases, decided it couldn't reach the issue.
Other First Amendment cases, and I leave it to you guys to what you'd like to talk about in the time we have before we start taking questions, but there was this interesting case involving trademarks, Vidal versus Elster, an opinion written by Justice Thomas about kind of what the framework should be for thinking about constitutional questions, and a division on the court that a lot of people have commented on between Justice Thomas and Justice Barrett, both Republican appointees, of course, both originalists of some kind or another, but in which there is this interesting interchange about how much the history and tradition framework that the court has increasingly talked about the last few years, how much traction that has in some of these areas. So,
yeah, that is a fascinating case. The facts here are there's a T-shirt, and the caption on the T-shirt is "Trump too small" with a finger going like this. You know, enlightened political discourse protected. But so the guy wants to get a trademark on this "Trump too small" T-shirt, and the trademark office has a rule that says if you mention a living person, you need their consent if you want to trademark their name. And the court says that's consistent with the history and tradition of trademark in this country. There's no First Amendment violation by having to go and receive consent from the living person before you trademark their name. But to your point, Professor, there is this fascinating interplay between Justice Thomas, who says history and tradition are the rule here, and the history and tradition supports the validity of this rule, no First Amendment violation, and Justice Barrett, who is nervous about using history and tradition as the barometer for constitutionality. And this is, you begin to see this history and tradition idea, so you put it originalist of some sort or the other. It's going to be a very interesting area to watch in the coming years, this term and to come. In the Second Amendment context, the court has looked to history and tradition in deciding cases like Bruin, right, where we analyze how constitutional or not regulations on firearms are. Now you're seeing history and tradition imported into other areas of Bill of Rights litigation, including the First Amendment. And I think it's Justice Sotomayor who has the line I like here, which is saying, relying on history and tradition to decide these cases is like stepping into a crowded cocktail party and looking over everyone's heads and only finding your friends, right? To find your friends in the room and go talk to them. In other words, history and tradition can be manipulated in certain ways, right? And it can give a sheen, a veneer of plausibility and coherence to competing doctrines. And right now, in the First Amendment world, we're seeing a lot of fights over, well, wait a second, who gets to decide the history? And when are we starting the line of the history? And does that mean that everything post-1960 is no good? Because you might not like it if we went back to, say, the Comstock era for history and tradition.
That's right. And that's why relying on history and tradition alone in the First Amendment context is so fraught, because for the first 141 years of our existence as a nation, there were no decisions by the Supreme Court upholding a First Amendment right. First Amendment doctrine didn't begin until the end of the first third of the 20th century. And so the development of First Amendment doctrine is a 20th century thing. You look back in the past, you have Anthony Comstock, who for 40 years basically served as the arbiter of virtue and vice in America when there were no First Amendment constraints. You go back further and you have the Alien and Sedition Acts. And if you're simply looking for historical examples of suppression, and then you argue that that's the basis for which you are interpreting First Amendment rights, you can see the problem right away. And that's why Justice Barrett, I think, very prudently said, okay, history is one of the things we look to, but it's not the only thing that we look to. We also look at First Amendment doctrine. We look at the development of these constitutional principles. And so I think it's a really good example of how there is a nuanced bench. They're not operating in lockstep among the kinds of political narratives that you see in the usual press accounts of what the Supreme Court is doing.
They're taking the job seriously.
Yeah.
Looking ahead to the current term, 2024-2025, which the court just convened a few weeks ago, not too many First Amendment cases on the docket yet. There is one significant one, though, involving an age verification requirement out of Texas. That'll be interesting to see. You want to talk about that case?
Yeah, this is a statute passed in Texas that would require websites that are more than 33% adult content to verify the ages of visitors. There's also a requirement that websites put in 14-point font a warning from the state health department about the mental health impact of looking at pornography, and is fairly overwrought. The Fifth Circuit, in hearing an appeal brought by the adult industry, said that the state could not compel that warning label, that these websites were not like, say, packs of cigarettes or other kinds of consumer goods in that way. In fact, what you're regulating here is speech that's protected by the First Amendment, and so First Amendment considerations come into play. But the Fifth Circuit did not apply what has for a generation been the level of constitutional scrutiny put on restrictions on adult content and any kind of content-based restrictions, strict scrutiny. Instead, it says we're going to use rational basis scrutiny. In other words, is it reasonably related to the government interest?
Yeah, close enough for government work.
Close enough for government work. So the court's going to hear that one. Stay tuned. That should be an interesting case. Kind of at issue here is whether or not the Circuit Courts of Appeals can write Supreme Court precedent out of the book. So that's kind of a fundamental tussle going on between the Fifth Circuit and the Supreme Court.
Well, the Fifth Circuit hasn't been having a good run at the Supreme Court, and I think this is it's foreshadowing what may be likely to happen in this case. And it harkens back to that series of cases that began with Reno versus ACLU. There was about a 10-year period in which there was litigation involving various federal and state laws, very much like this law. And those cases uniformly came down on the side of the First Amendment, finding that online media have full protection under the First Amendment, and that the various measures being adopted by the states were not the least restrictive means. Now, the Fifth Circuit dealt with all of that history by saying, it doesn't really exist, or it doesn't mean what it said. And so far, you have district courts around the country looking at what the Fifth Circuit said and saying, no, I don't think so. And so there are now 6 different states in which various kinds of social media regulations of some broader kind have been enjoined as these cases are being litigated. And in the interest of full disclosure, we're working in 3 of those cases. And what the Supreme Court will do in the coming term will have a huge influence on the future of those kinds of laws.
Let's turn to some audience questions. I said we come back to Chevron, maybe, or
Yeah.
Loper Bright.
Sure, let's do it.
Doesn't deference to agency experts make for better laws and policies on complex issues?
Sure, that is certainly the argument, and I guess we will see. All right, we're about to do a little bit of a control A/B test here. I guess we will see.
Yeah, but the question is what you're asking the courts to defer to. What Chevron is about isn't to defer to the specific technical expertise of the agencies. It is asking the courts to defer to how the agencies interpret what the law is.
That's right.
Which is what Congress was supposed to do in the first place. And then the experts will bring their expertise to what they've been directed to do by Congress. But as we mentioned earlier, this is a doctrine that has made Congress a lot sloppier, a lot lazier, and as a result, it's basically given a blank check to how agencies interpret the law. Now, certainly, if Congress directs an agency to deal with this area of expertise, that's not controversial. I mean, if Congress is specific, then you don't have the Chevron problem.
Right. Like I was explaining to some students recently, it's not like the FDA now is inhibited from doing drug approvals. It's not like the Congress now has to go through and do all the drug approvals after clinical trials, right? the FDA Act gives the FDA that authority expressly. The scientific experts there make those determinations. It's just where it's involving the interpretation of the statute that the agency has that the issue is.
That's right.
That's right.
Another question, public accommodation companies like hotels, restaurants are private but cannot discriminate. Why should social media companies be different?
This is the animating question in the net choice cases, and it's fascinating to see the interplay between the majority and the dissent, because this is the argument put forth by Justice Thomas, I believe, this is his particular avenue. They are different in type because when you are talking about a social media company, just as when you're talking about a newspaper, you're talking about pure speech. There is no government role to ensure access to speech in that way at a private company. It's just a fundamentally different. That's where the analogy breaks down immediately for me.
And there's not a hotel amendment to the Constitution.
Right.
And that has really been well established for a long time, that public accommodation laws don't trump the First Amendment. And that was established in the case that Will mentioned earlier, the Hurley case, which is whether or not a gay rights contingent had a First Amendment right, or rather, whether the parade organizers had a First Amendment right to exclude a gay rights contingent. And the court looked at that and said, we understand that Massachusetts public accommodation law covers this, but nonetheless, the First Amendment says that the parade organizers, even if they don't have a particularly articulable message, they have a right to control who marches in their parade. And that has been sort of the animating principle of the court has recently reaffirmed in various cases.
But the racist hotel owner does not have a free speech right.
Correct.
With regard, because it's not expressive activity.
That's right. And that's the difference between your hotel and, as Bob alluded to, something like your cake or your wedding website, right? Those are expressive activities, and thus the First Amendment protects in those cases.
Can you speak about Grants Pass versus Johnson that allowed municipalities to criminalize homelessness? So this was a constitutional challenge to a local Oregon town's criminal provisions with regard to anti-vagrancy, anti-camping. There was a constitutional challenge on the Eighth Amendment. This was cruel and unusual because it was criminalizing a class of persons and not merely behavior. And the Supreme Court said, no, that the town could do this. I don't know if you have any thoughts about that case.
Yeah, again, this is me veering into pure punditry, which my wife will tell you is dangerous, so I don't have too much to add here other than that. I give the court credit for taking up a creative argument and thinking it through. That's about where I'll leave it.
And I'm aware of the case, but I don't know enough to say anything intelligent about it.
20 years from now, what will be the most consequential First Amendment case recently decided? Or 50 years from now?
Well, we'll see. I guess we'll stick around, right? The century is young.
Well, I mean, it's an interesting question because how young First Amendment doctrine is when you think about it. I mean, it really began in the 1930s. There were some precursors right after World War I, but it didn't really get started until 1931. And it was really through the middle of the 20th century that you saw developments in First Amendment law in response to various religious movements, in response to Jehovah's Witnesses, chief among them, also in response to the civil rights movement, the anti-war movement, women's rights, you name it. And you have this development going along through the 20th century, student rights as well. And so what's happening, though, is there are some who are arguing that, well, we have too many rights now. First Amendment isn't so great. And there's a real trend in academic scholarship trying to reinforce that principle, and they're the ones teaching future lawyers and future judges. And the biggest challenge, I think, will not be any particular case, but whether or not the principles that were developed through the 20th century will continue in response to these kinds of trends.
Yeah, the last point I'll raise there, I'll give you a serious answer. I agree with everything Bob said. Whether or not the First Amendment can withstand the intense polarization on both sides and the interest in subverting speech on both sides will be very interesting. The other point I'll give you, and this is thinking of the upcoming speakers here in this great room, artificial intelligence. When the court makes its decision in the net choice cases, which we've talked about, essentially saying hands off private companies online, social media is engaged in the business of speech, you saw some interesting moves from the Solicitor General and even some of the justices saying, watch this space. When we get to algorithms, right? When we get to artificial intelligence, when we get to other types of speech mediated through digital means, there will be fights to come as to what role, if any, the government may have in those arenas. And I think we had a good, from my vantage point as a First Amendment attorney, as a civil libertarian, I think we had a good first start here, where the court did not carve out a big social media exception for government power. But we will see. When the Solicitor General is masterfully arguing these cases, she does leave some space on the board for future regulation of algorithmic speech. So stay tuned.
Well, and that is a point worth mentioning too, and that is the role of the Solicitor General's office in arguing those cases. This, as far as I'm able to remember, is really unprecedented, where you have, in all of these paired cases going to the court, you have the Solicitor General's office not just filing amicus briefs, but getting argument time and arguing, and in many cases, supporting the First Amendment side of the argument. Now, it's rare when you have government lawyers arguing for limits on government power, but that's what was going on with the Solicitor General's office, at least in many of those cases. Some of the positions were a little bit more nuanced, but again, I think this is really an historic development.
This is actually a question for me, not an audience question, but something Will said called it to mind. Do you think, I guess I'll just leave it open-ended, over the last year, a lot of controversy about campus protests after October 7th. FIRE, of course, started as a campus-focused organization. Now you have a broader mission. But I guess, do you think what are the legacies of this? The president of Penn, of course, forced to resign in part of because of her answers in a congressional hearing on free speech issues. So just what should we think about those issues today?
We've been very busy. How much time do we have left? Where can I start? You know, the hope is always that as folks encounter limitations on speech, that they recognize the importance of a principled, nonpartisan defense of speech that isn't contingent upon the message. That can be incredibly difficult when speech is about in my career, 18 years doing this work, has been the most contentious issue, let alone abortion, Republicans, Democrats, anything. Israel and Palestine has always been the most radioactive, most corrosive, most intensely felt debate on campus. So this has been a searing year. One thing that we've committed to doing at FIRE is to remind folks, we've called it internally going back to basics. What are the basic limits? The First Amendment protects a great deal of speech, but there are narrow, carefully tailored, but important exceptions. True threats are not protected. If you are threatening to shoot up the Jewish fraternity at Cornell, as one disturbed young man did, you can expect to be arrested, as he was. Incitement to violence is a carefully defined term. It's not wide open. It has to be speech that is directed to and likely to incite imminent unlawful conduct, violence, but reminding folks about the importance of that narrow tailoring is important. And finally, pure old violence, right? Telling folks that violence is never protected by the First Amendment. I mean, it feels like the basics, but on campus, that's been our job for the past year.
Tearing down someone else's posters.
Tearing down someone else's
Not
posters.
protected speech.
Not protected. So we've done a full court press. I'm very proud of it, if I may, thefire.org, to remind folks that no matter their message, that the First Amendment protects a vast majority of speech, but here are these narrowly, carefully tailored exceptions. So my hope to you, Professor, is that we've inspired folks and we will move forward with a better understanding of what is protected and what isn't. But I'll tell you, there's a lot of work to do.
Yeah, and one of the more frustrating things about it, too, is seeing the fact that some people are trying to make political hay out of this. Speaking of the hearing that you referenced, where you're simply trying to score political points by really stoking misunderstanding about what's protected and what isn't.
So it's a student question. Given that the president is elected by the will of the people, are his Supreme Court nominations an extension of their will, and should nominations be automatically confirmed?
No.
Yeah, Bob's argued and won a couple of Supreme Court cases, so I'm going to defer to him on that one. But yeah, no, I think that's right. No, the Senate has an important role here, right?
As much as I detest the confirmation process and how it has made the process more political, the idea of having a president simply rubber stamp a choice is, I think, a very bad idea. And particularly one if you're simply saying that the president of whatever political party is going to nominate people to do their bidding. This is an independent branch of government. It's designed that way. The people appointed to the Supreme Court have lifetime appointments for a reason, and it's to provide that kind of political insulation. Anything that makes the court more political, either structurally or, if the mindset gets developed that it is an institution that's beholden to the president, then you have really messed around with the basic design of the American Republic.
Another question, will efforts to pack the court have a chilling effect on the current court's willingness to render decisions which might offend those wishing to pack the court? And I'll fold that in with a question that I said we were going to ask because it is such a topic of interest to people. So one of the decisions that has outraged people who want to pack the court is the decision with regard to presidential immunity that the court issued. So both, is there a risk of a chilling effect here? And to what extent is the presidential immunity decision, rightly or wrongly, motivating some of that energy?
I think this court has been uncowed, right? I think the interplay between Congress, Democratic lawmakers, and the Chief Justice has been very interesting over the past year, with the Chief Justice rejecting the idea that Congress has some role or authority to essentially coerce the court into adopting some kind of ethical code. As Bob just said, it's an independent branch of government. So I think that the chilling effect, I don't imagine you'll see one. I can't imagine what it would look like. As for the presidential immunity decision, I guess we'll stay tuned. We'll see the contours of it. Sooner rather than later. I guess I don't have much other than to say I think there's more yet to be written.
Yeah, and on a practical level, I think the members of the court are quite aware that to have the level of political capital necessary to adopt any of those measures, you're going to have to be transported to a different universe first.
That's right.
So we have time for one more question, I'm told. So I'll go with a very timely question. Again, not in the First Amendment, but you guys have been around the block, as have I. Given that the courts were hesitant to get involved in the 2020 election, including the Supreme Court, what stance do you think the courts will have if the coming 2024 election is in dispute? Yeah, something light to end with. Yeah.
All right. Is the bar open? Because yeah, that's a good question. If I had a crystal ball, I'd probably break it. I don't know. We will see.
Yeah, I think can we safely say that the courts will eagerly avoid having to weigh on these issues?
Well, just today, there's a push to get the Pennsylvania naked ballot question before the court. So we'll see. The courts will have something to say. Watch this space.
Yeah. Well, when you think about the lasting legacy, the negative legacy of Bush versus Gore. Anything that increases sort of the political focus on the high court, I think, again, is destructive. And if the premise of your question is, if there's going to be a dispute over the outcome of this election, then I think we can take that as granted. I mean, there will be a dispute over the outcome of this election, whichever way it goes.
Right. As someone who worked for George W. Bush, I have to note, he always led the count, right? Whatever you think of Bush versus Gore.
Hanging chads or no?
But it seems quaint, doesn't it?
Yeah.
Yeah. The 2000 election seems like very specific times. Yeah. Well, great. Well, thanks so much. Please join me in thanking our panelists here.
Michael, Bob, Will, thank you so much. That last question almost seems like a setup to hear some answers to that question. Join us next Thursday at Liberty Hill, where we will have a discussion on an analysis of the election next Thursday at Liberty Hill. A reminder on the CLEs, please come right over here for your CLEs and surveys. Do we have that up on the? Yes, there you go. Take a moment, fill out a survey. We appreciate it. And finally, we'll all of our students come up for a picture with our speakers. Have a wonderful evening. And my thanks again to our speakers and to FIRE for their partnership. Thank you.